I'm so glad that you're all here, and I'm introducing Kristen Boney. Did I say your name right, Kristen?
Yes, that's perfect.
Great, great. And if you would go ahead and tell us a little bit more about what, who you are and what you're going to share with us today, that would be fantastic. Thank you.
Sure. My name is Kristen Boney, and I'm a supervising attorney with legal assistance for seniors in Oakland. As part of my practice, I represent older adults, people 50 and over, who are seeking guardianship of children in their care. And I'm also appointed by the court to represent older adults in conservatorship cases where someone has petitioned the court to say that my client isn't able to manage their finances or their personal care. And so the court appoints us to represent people in those situations.
Okay.
And we'll have more information about legal assistance for seniors in a little bit on our PowerPoint. But today I'm going to be talking about advanced planning and the importance of that. So Advance Health Care Directives and powers of attorney.
What is their interest in the subject at this point in their lives? Is it about being caregivers or for themselves? Just to take a minute. Michelle, do you want to share that?
Yes. I'm just concerned about when I, get in a state that I'm not able to do for myself and take care of myself. I just need something to be planned because I know how I want things to be done, if something were to go down. And I just need to have something in place because I don't need anyone to, make plans outside of the plans that I have, my concerns.
Fantastic. Yeah. So, and Robin, are you a professional or your interest for yourself or?
Yes, Kristen, I don't know if you remember me.
Hi, Robin.
Yeah. I had spent many years in APS, and now I am a care manager with Senior Alternatives Home Care and Care Management.
Okay, thank you. So let's get the scoop, Kristen.
Okay, well, we're here today to discuss planning for the future. So as I said, advanced healthcare directives, durable powers of attorney, and capacity. So the organization where I work is called Legal Assistance for Seniors, and our mission is to ensure the independence and dignity of seniors by protecting their legal rights through education, counseling, and advocacy. We're in Oakland, and we serve people that live in Alameda County, and our services are free. And these are some of the legal areas that we can help with. We can assist older adults who are on government benefits and having issues with those, such as Social Security, SSI, and CAPI. We can help with senior immigration issues, including naturalization. We have a large practice area, unfortunately, in elder abuse prevention, where we assist older adults who need to obtain a restraining order against someone who is abusing them. One of the programs I work in, Guardianships, assists with kin caregiver issues. We also assist with planning for the future and any issues that older adults are having around their healthcare coverage, including Medicare and Medi-Cal and other related insurance plans. And we have a housing law team, which is our newest team, which is limited on a case-by-case basis, but we do encourage people who are having housing law issues to call, because we can always refer people in that area or other areas of law to other organizations if we're not able to assist. Our health insurance counseling and advocacy program, or HICAP, provides assistance with Medicare and related health insurance products by offering objective information and counseling to help consumers understand their benefits and rights. I know around this time of year, people just get inundated with information from insurance companies trying to sell them things, and HICAP is a great place to go to talk about what programs to sign up for, as well as any issues that happen once you're signed up for a program. It's completely objective. We're not related. No one's paying us to offer the information or to sell their products. In HICAP, we receive federal and state funds through the Alameda County Area Agency on Aging. And when people call us, they're set up to meet with a counselor who is registered with the state of California and has to fulfill continuing education requirements. We offer HICAP appointments at over 30 locations throughout the county, and we also provide educational presentations throughout the county to help Medicare beneficiaries know their rights and options. If there is an issue that a volunteer is not able to help with, those cases can be referred to our legal department for assistance from an attorney. And all of these services are free. So when we're talking about advanced planning, why is it important to plan now? We want to be prepared for unexpected occurrences such as accidents or illnesses, and ensure that your wishes and preferences are known and respected. Planning documents like the ones that we're going to talk about today can prevent elder abuse. It's never easy to think about a time when you're going to need help taking care of yourself. So it's really important to make plans now that will help protect you in case that time comes. So what is an Advance Health Care Directive, often abbreviated AHCD? This is a legal document, and it helps make sure that your healthcare wishes are known and will be considered when you're unable to speak for yourself. And one example is on the left. This is one that's done by the California Medical Association that we really like. It's an Advance Health Care Directive kit, and we'll have their contact information later on for ordering these kits if it's something that you're interested in looking into. The healthcare directive lets you appoint an agent if you want to, who would be the person to make decisions for you if you were unable to. It also lets you give instructions about your healthcare and express your wishes about organ and tissue donation. Appointing an agent is optional. People can fill out this Advanced Healthcare Directive whether they want to appoint an agent or not. A lot of people approach me at presentations and say, well, I don't really have someone that I would trust to do this for me. And even if you don't have someone, you can still fill out the directive to let your wishes be known. If you do appoint an agent, you can give them the authority to make healthcare decisions for you and make personal care decisions, including whether you need a caregiver, what kind of level of care you need. They can arrange for your housing and hire in-home help. You can also authorize them to donate your mail, to open your mail and to donate your organs, tissues, and parts, authorize an autopsy, and just direct the disposition of your remains after you pass away. So it's a really important job, and the agent has to follow your wishes. When you're thinking about who to appoint as an agent, you can appoint just about anyone who's 18 or over. You should name someone that you trust and someone that's comfortable with your decisions. So you want to talk to the person that you plan to appoint and let them know if you would want all measures to be taken at the end of your life, then you want to make sure they'd be comfortable with that. If you would want to just be kept comfortable, if you had a terminal diagnosis, then you want to make sure that they're comfortable with that too. You can also name an alternate agent. If the first agent is not able to act for you, the alternate can step in. Or you can name anyone that you would not want to make decisions for you. If you feel like there's somebody in your family or in your circle that wouldn't carry out your wishes, you might want to name them. And professional fiduciaries are an option. They do charge for their services, but sometimes people decide that they would prefer to have a neutral person rather than a friend or family member to make important decisions for them. And when we say you can appoint almost anyone, there's a note at the bottom here that says your agent may not be an operator or employee of a community care facility or residential care facility where you're receiving care, or your supervising healthcare provider or an employee of a healthcare institution where you're receiving care, unless that person is related to you or is a coworker. Just a safeguard there to consider. In the healthcare instructions part of the directive, you can state your wishes about your healthcare if you're not able to express them yourself. This includes decisions about life-sustaining treatment. And with that, if you choose not to prolong your life as long as possible, if you are an organ donor, your agent might consent, if it comes to that time, to a temporary medical procedure that's necessary just to evaluate or maintain your organs, tissues, or parts, so your decision to donate can be honored. You can also put in the directive any other specific choices you might have, including whether you would want to have CPR, be put on a ventilator, have dialysis, be on a feeding tube, and other medical decisions. You know, sometimes if you have a specific condition, you may talk to your doctor and decide, if it gets to this point, I do or do not want this treatment. And it's really helpful to have that written down. For your agent, oftentimes they are somebody that's close to you, and if it comes time to make these decisions, it's a really stressful situation for them. It's very emotional, and if they can have the sense that they're carrying out your instructions rather than having to think about what you might want if you haven't talked about it, it's a real gift to them to give them clear instructions. For organ donation, you can indicate whether or not you want to donate organs, and you can specify which organs. You can also specify the purpose for the donation. You can make it broad, or you can specify whether you would or would not want someone else to have your organs for a transplant, to be used for therapy, research, or education. If you leave the donation section blank, then your agent or another state authorized agent can make the decision about whether or not to donate your organs. So be sure to fill out the section if you have specific wishes so you can make sure they're followed. You may also have wishes about an autopsy or how you want your body to be disposed of after death, including burial or cremation. So it's really helpful, again, to, if you have specific wishes, to write them down. When you're completing a healthcare directive, the document either has to be notarized or you can have 2 witness signatures. And the witnesses cannot be your agent or your alternate agent or your healthcare provider or their employees. And only one of the witnesses can be related by blood or marriage. And I like the CMA form, the yellow form that we saw the first page of before, because it spells out who the witnesses can be. If you're living in a nursing home, you also have to have someone from the ombudsman's office sign the document as a witness. And you don't need an attorney to complete an advance health care directive. Now, being an attorney, I always recommend that if people can, that they contact a probate attorney to fill out not only the healthcare directive and power of attorney that we'll talk about, but also a will and or a trust. It is ideal to have an attorney fill out all of these documents with you so that you know that none of the documents conflict with each other and that they all comply with current California law. But it's not required to have an attorney to complete these documents. If you have any questions about filling out these forms, you can consult with your doctor. I know that Kaiser has a form that they offer, and they have, I think that they have sessions, I don't know if they're group or individual, where they can assist with filling it out, and or an estate planning attorney, like I mentioned. And you'll get these materials, and we have the website here for the Alameda County Bar Association's lawyer referral service. You can also call them for a referral. And then there are many versions available online. This is the website for the California Medical Association. I think it just costs a few dollars there. The California Attorney General also has a form that's available for free. And we really like the 5 wishes form because it really guides you through the types of decisions that might need to be made during end-of-life care, and lets you think about and decide what kinds of things you would want that you might not think of on your own. And your healthcare provider, like I mentioned, Kaiser, they may offer their own form. And if they do, it can be helpful to use it because when it comes time, they're familiar with that form. So I would definitely check with them. The physician orders for life-sustaining treatment, or POLST, is a brief form that's completed by you and your doctor, and it reflects your preferences regarding certain end-of-life treatment options. And once this document is signed, it's considered to be valid medical orders. So this is a document that you talk to your doctor about and discuss your values and wishes for end-of-life treatment. And the doctor will complete it based on your wishes and your medical condition. It has to be signed by your doctor and by you or your legally recognized healthcare decision maker. So your agent under a healthcare directive could work with your doctor to have this filled out. And there's no witness necessary. The POLST form will specify your preferences regarding resuscitation, which is commonly known as CPR, or you can decide that you want orders saying do not resuscitate, or DNR. You can talk to your doctor about medical interventions, ranging from comfort care only to full treatments, and you can talk about different treatments that you may or may not want, including artificially administered nutrition, which is commonly known as tube feeding. So a lot of times you'll be filling out a POLST when you know that you have a specific condition and you're thinking about end-of-life care. And again, it is something that you talk to your doctor about. The POLST and the healthcare directive, the POLST serves as a complement to an advance healthcare directive. It converts your healthcare wishes into valid physician's orders. The healthcare directive is the document that allows you to appoint a legal agent. The POLST doesn't allow you to do that. The POLST is more of a brief form, very specifically about specific medical orders about a condition that you have. Now, what is a durable power of attorney? It's often abbreviated DPOA. This document allows an individual, who's called the principal, to appoint someone, the agent, to manage some or all of their financial decision-making. The law requires the agent to act in the principal's best interests. The principal is sharing decision-making with authority with the agent, not giving up their authority. No court is involved, which makes this convenient, private, and inexpensive. However, it also makes it easy to abuse. So you want to choose an agent who is trustworthy, such as a family member or friend. And again, somebody that's going to carry out your wishes and that you trust to handle money. You know, somebody that might be a great healthcare agent because maybe they have experience working in the healthcare field, or you just really like how they've made healthcare decisions for someone else or for themselves. Might not be the best power of attorney agent if they've had issues with their personal finances or something like that. So you really want to think, when you're thinking about the people who you want in these positions, think about the qualities that would make them good for that. The agent's powers can be as broad or as limited as you choose. Examples of powers include managing your public benefits, handling banking, and real estate transactions. So this can be a lot of authority to manage your savings and your finances. So you really want to be careful who you appoint. In the power of attorney document, if you make the agent's powers durable, that means that the agent can continue to act even if the principal loses mental capacity to make their own decisions. So it's really important that that language is in there, because the main point of a power of attorney is to have someone in place to make decisions for you if you're not able to. So if you make it durable, it means that their powers can start now and continue on after you lose mental capacity. Alternatively, the agent can have a springing power of attorney that has a condition that makes it take effect. Usually when the individual becomes unable to manage their own finances. And if you want to have this, if you don't want them to have authority until you become unable to manage your own finances, the document needs to specify how a third party, like a bank, knows that the principal can't manage their own finances and the agent, it's time for them to step in. For example, you could say that a declaration from a doctor or a friend will be attached to the power of attorney in order for the agent to be able to act. The power of attorney can designate 2 agents, or you can have 1 agent with 1 or more alternates in case the first agent isn't able to act. And you want to keep this current. You know, oftentimes people fill out this document and then maybe 10 or 20 years later, it becomes time for the agent to step in, and the agent you named at that point might be deceased or otherwise unable to act. So you want to make sure that you always have an agent named who would be able to act for you. The signature on the document has to be notarized to ensure that banks and other institutions will honor the durable power of attorney. So it's not a good idea to just have witnesses on this one. You really need to have this notarized, because the agent's going to be dealing with banks and government agencies. If the agent is going to handle real estate transactions, they should record the DPOA at the county recorder's office. And if you decide at any time that you don't want your agent to be your agent anymore, you can revoke the DPOA by providing written notice to the agent of the revocation. Advance Health Care Directives and durable powers of attorney are really important parts of an estate plan, along with a will, and for some people, a trust. So you want to consult with an estate planning attorney to discuss these documents, ideally. This will ensure that your wishes are carried out during your lifetime and after you pass away. And if one attorney is creating the whole plan, then you know that parts of the plan won't conflict with other parts of it. If you don't create an estate plan, then only your legal relatives will inherit your property after death. So this is really important. You know, with my guardianship clients, I talk to them about the fact that when you become guardian of a minor, that doesn't change any inheritance for that child. So if you want that child to inherit, you need to have a written estate plan. And there are a lot of other examples where people might not want their estate or their property to go to their closest legal relatives. So it's really important to have your wishes in writing for that too. Once you've completed the documents, you want to keep the original in a safe place where your loved ones can find it. You can give copies to the people you have appointed as your agents and to family members and anyone else who may be called if there's an emergency. You also want to give your doctor a copy of the healthcare directive, or you know, if it's a bigger medical plan like Kaiser, they have procedures to be able to keep that on You can revoke or change a healthcare directive or durable power of attorney at any time that you have capacity to do so. You do want to make sure that your agents get notice of that in writing to be fair to them and make sure that they know they can't act after that point. And often healthcare directive kits have wallet cards to keep with you, which is really helpful in case of an emergency. It says who your agent is and it has their contact information. So emergency services can find that with you. So when should I complete advanced planning documents? It's best to complete these documents as soon as you determine your wishes. If you wait too long, you may lose the capacity to understand and execute the documents. And even if that doesn't happen, you never know when an emergency situation might come up when someone needs to make decisions for you. When I was about 30, I had to go into the hospital all of a sudden for emergency surgery. And so I'm sitting up before the surgery telling my fiance what I would want, asking the nurses to ask him if they had any questions during the surgery. And that's really not the time you want to be making the decisions, right? You really want it to be when you can be calm and reflective, and the person that you're going to be appointed can also be calm and not stressed out. So it's really not, I don't say this because I work with older adults. I say this because I've had it happen. It's very important to just have these documents in place just in case. And no one should sign estate planning documents that they're unable to understand or documents that don't express their wishes. If that happens, it could result in the documents being challenged in court, which is extremely stressful, extremely expensive for everyone involved, and not something you want to have happen. So you never want to sign documents or have anyone sign documents that are not fully understood by the person signing. So when we talk about capacity, our society has a lot of biases related to older adults and their capacity to understand. California law presumes that all people have the capacity to make decisions and to be responsible for their acts or decisions. And this is found in state law in the probate code. The legal standard for capacity depends on the complexity of the document being signed. And having a diagnosis is not definitive. A lot of times people get a diagnosis of Alzheimer's type dementia or another mild cognitive issue, and it doesn't mean that as soon as they have that diagnosis, they can't understand and sign any legal documents. It really is, and it really depends on the individual. In general, capacity requires the ability to communicate the decision by any means and to understand and appreciate the rights, duties, and responsibilities created by or affected by the decision. So when we're thinking about the decision of appointing an agent, what does this mean? What are my rights going to be? What are their responsibilities going to be? The probable consequences for the decision maker, and where appropriate, the people that are affected by the decision. So, this means that this person's going to make decisions for me after I become unable to. Do I feel safe with that? Do I understand that that means they can make these really important decisions for me? And then the significant risks, benefits, and reasonable alternatives involved in the decision. So for any decision, this is what is required to have capacity to make it. And so our contact information is here. Legal assistance for seniors, you can call us anytime or have your clients call us. We do represent older adults, and so we're not able to give advice to family members or to caregivers because we might have a conflict later on if we were appointed by the court to represent the older adult that we would be talking about. So for example, we advise, if we advise an adult daughter who says, my mom isn't able to understand any estate planning documents, what do I do? If we tell her she needs to file for a conservatorship and then she does that, we've now advised her we can't represent her mom if we get appointed to represent her. And the court really depends on us in that role. And so we do have to be very strict that we can't give advice about specific situations to family members. But sometimes family members are helpful in setting up appointments for people. If someone calls and says that their mom needs a restraining order against a family member or person that they know, sometimes the caller can help us set up the appointment, but we need to meet with the older adult alone to determine if they want us to represent them and if they have capacity to engage in that relationship. But people are always welcome to call us, and if they have questions about an area of law that we don't handle, we can give the referrals to the older adult who's seeking help. So our website is here. We used to be able to accommodate drop-ins, but as you may see, a lot of us are working from home these days or on in a hybrid capacity. So I do have our address here, but we really encourage people to call rather than drop in because we usually don't have someone available to assist if people drop in. And then we have the information here for HICAP if you want to make a HICAP appointment. And then there is a statewide number available too, because every county has a HICAP program. And so we run the program for Alameda County, and this is a statewide number for people in other counties. And you can also call our office if you want us to come out for another community education program like this, or for another organization. You can always call and ask for that department. So with that, I'm curious what questions you all have.
Actually, I do have a question. Let's see.
Is that you, Robin?
Yeah, it is actually. And I'm very interested in the fact that a person can revoke their DPOA from a person, and even though they have a diagnosis of Alzheimer's. And I'm thinking of a specific case actually. And I don't know whether we should pursue it with that person. I mean, she had, be very brief, she appointed a relative who in a way has been making some good decisions and maybe some questionable ones financially. And so how do you think we should proceed?
Well, I can't give any advice on individual
right.
cases, but I know.
But generally, in
general,
idea.
Yeah, it's up to the principal. If they, we had talked about the standard of capacity a minute ago. If they understand what the decision is, what a revocation is, and revocation is a legal term. So if they understand, I don't want this person to make decisions for me anymore. Yeah. I understand that means I might not have somebody to make decisions. They've got to be able to think through all of the consequences, right? If I revoke this, is this person paying my bills? Am I able to pay my own bills? And that's really something. Somebody has capacity until a judge says they don't, basically. But a lot of times, if it's a conservatorship case, or say that this person revoked the power of attorney document and then the former agent brought that to court, questioned that revocation on the basis of capacity, the court would probably want to see an evaluation by a neuropsychologist to really delve into whether that person had capacity to make that decision, that very specific decision, not necessarily capacity to execute a complex trust, or which is a very high standard, or a will, which is a very low standard. Every document kind of has a different standard depending on what it is and what the consequences are of signing it. And so it can be a really good idea to get the gold standard of evaluation is a neuropsychologist. A lot of times we see in conservatorship cases, people going to a general practitioner, having them fill out a capacity declaration, but that might be based on a 15-minute conversation with someone. And I know, we know in our work with people that have major neurocognitive disorders, sometimes it takes a while for you to realize that, this person doesn't remember what we were talking about a half hour ago. If a doctor talks to them 15 minutes, they're not really getting an understanding that can be gleaned from a neuropsychologist battery of testing to see where it is that they have cognitive deficits. They might not be able to do math anymore, but they surely might be able to decide who they want to help them do that.
It can be very dangerous to appoint a person to be their DPOA, especially if they have access to the money.
And that's why we tell people it has to be somebody you trust implicitly. And think about their ability to manage money. Are they going to be tempted, if they're going through a bankruptcy and they're going to be tempted to take some of your money on the side? Because it's illegal for them to do that, but they'd have to be caught and brought to justice. So
there's no monitoring of a DPOA, is there? None. There's no oversight.
Right.
And so
Yeah,
that
that's the thing.
is the issue, is then when you bring it to the police, very often they will say, but that person had a legal right to make those changes financially. That person had a legal right to extract money from the account. So that is the dilemma, I think,
Yeah, and
of
the
a
decisions have to be.
DPOA that does not have any oversight. When you appoint a fiduciary, very often they won't be a crook.
Right, and I think one safeguard is if you wanted to appoint 2 agents, it's cumbersome, but you can say in the document, I want 2 agents and they
2
have to act
agents.
together.
Mhm.
It
Yeah.
would mean they would have to sign every check, go to every bank appointment,
Yeah,
that
yeah.
would be a
a
safeguard.
pain.
And to
Yeah.
me, if you're already thinking you need that safeguard, maybe these aren't the people to appoint. But
Yeah.
it is hard because a lot of times you don't have somebody that has a lot of experience managing finances, is financially independent, that you can appoint. So you really just have to think about, can I trust this person if I can't monitor them? And if the answer is no, then it's not a good idea to appoint them. But yeah, I think capacity is it's such a nuanced determination. And I think, as lawyers, when lawyers try to determine, right, in any estate planning appointment, you have to determine, do I think this person understands these documents that I'm explaining to them? Should I have them sign it? And sometimes it's so clear as an attorney who handles estate planning, like I can't, this person doesn't understand why this might be helpful to them someday. I can't have them sign it. I've had that in meeting with clients where, even if I share my story of like, well, what if you were in the hospital suddenly and you needed somebody to pay your bills, would you want to sign a document appointing somebody? And they're like, oh no, that would never happen to me. And it's like, well then, okay, you really don't understand how this could be helpful. So it's, even if you did want it, I wouldn't feel comfortable as an attorney having someone sign it. Because attorneys could get sued for malpractice if they have someone sign documents and they don't have the capacity to do it.
Yeah.
So some attorneys will recommend, if they have somebody where they feel like it's on the edge, will recommend them having an appointment with a neuropsychologist, because then they have an evaluation to back up the idea that this person had capacity at the time of signing.
One more caveat to my little case is that I think when this person appointed her relative, she was cognitively clear. She did not have Alzheimer's. This relative waited until she became very confused to start stealing from her. And that is a problem. That is a big issue, because then the police will say, well, she appointed this relative.
Right. And the question is there someone that can sue them for fraud? They have broken the law. If they are making decisions as an agent that aren't in the best interest of the principal, there is a page of the standard durable power of attorney form that is a page that's meant to inform the agent that they really have to make decisions in the best interest of the principal. They should not be using the principal's money for their purposes or commingling their money with the principal. It's just
they don't care.
Can I ask a question in relation to this conversation? So if another family member realizes that this person who was appointed is not dealing honestly, they can, what, Kristen, sue? Is that the language you use? That's what a person can do?
Well, so another family member wouldn't likely have the authority to sue on the principal's behalf unless they were an agent under the power of attorney or a conservator. So unfortunately, we encourage people to get these estate planning documents in place because they can help avoid the need for a conservator if you have someone trustworthy.
But given
right.
Not everybody gets it, clearly right. They choose the wrong person because, how do you know always? It sounds like you're saying there is nothing anybody can do.
Well, no. So I'm saying, say that someone appointed one agent under a power of attorney document and that agent is abusing the principal's finances. if there is someone else who's a friend or family member or the public guardian, there are agencies that do this, they could file a petition for conservatorship. And unfortunately, it's often a reason that I see stated in conservatorship cases where we're appointed is that the person did their estate planning documents, but the person they appointed as the agent or the trustee is abusing them. So someone else needs to step in as
So let me see if I can clarify. If that happens, the option is to get the person, the principal, conserved.
So, right. And that I'm not saying that that would be something that would work in every case or that the principal would be at that level of cognition where they would need a conservator.
That's the way you could, that's the only way that it can be redone.
That's right.
Unfortunately, I mean, we do see oftentimes that when these cases are reported to the police and the DA, they look into it and they're not always going to prosecute the person. And even if they did, the principal would still not have somebody that's trustworthy to make decisions for them. So unfortunately, a conservatorship should absolutely be a last resort. But if there is nothing else that can be done, like I said, sometimes we do get these petitions where we're appointed to represent someone who was a principal and was their fiduciary, their agent was abusing the authority that they had, which is really unfortunate.
And that person still had capacity, so you were able to help them with that.
Well, so oftentimes by the time it becomes a conservatorship petition, it's because the principal no longer has capacity, because if they had capacity and realized that the agent was abusing their authority, they could revoke that agent's authority and appoint somebody else. But a lot of times by the time somebody files a conservatorship petition, the person's cognition has declined to the point where they wouldn't be able to understand how to revoke a power of attorney and appoint a new agent.
And I would say that, most people, this is very difficult material to sort through. And, without an attorney, and that's why legal assistance for seniors is an agency I'm thinking we can really look to help, to help seniors navigate this incredibly difficult, territory. And that's what I'm, when I write up my my short version of this, I'm going to say legal assistance for seniors is there for you.
Well, and unfortunately, we don't have funding for estate planning for individuals to help individuals with estate planning. So we can do presentations like this where we talk about the importance of it. But unfortunately, there's not funding that we've been able to access to allow us to draft these documents for older adults or to help with that. So there is an organization called HERA, and I can email you their information. I think their website is just HERACA.org, but it's Housing and Economic Rights Advocates. And their whole mission is preserving family wealth. A lot of times we see a lot of our clients have a home that they purchased a long time ago and don't have a lot of other money available to be able to make an estate plan. And so HERA provides estate planning, but it's also, they don't have a whole lot of funding to do it. But they would be who I would call if I wasn't able to hire an estate planning attorney. People can call HERA, and they're a statewide organization. They're not just limited to Alameda County. So I would recommend that people call HERA. There's also Contra Costa Senior Legal Services for people in Contra Costa County. I think their website is, it's ccsls.org. And they provide some limited estate planning services. But unfortunately, LAS does it a little bit on a limited basis for cases that are referred by Adult Protective Services, where there's been elder abuse. Sometimes if APS refers a case to us, we're working on a restraining order. We might also handle a revocation of a power of attorney or something like that. But we don't have funding for members of the public to be able to come and access those services, unfortunately.
Can we ask you about durable power of attorney being for finances and or healthcare, that they could be two separate things.
Mhm.
It is typically two separate documents. It can be a little confusing because the document dealing with healthcare can either be called an Advance Health Care Directive or a durable power of attorney for healthcare. And so those documents are kind of accomplishing the same aim, but it's just two different documents. You could use one or the other.
So you, a person, could appoint an agent to speak for them medically, you know, what their healthcare wishes are, and that's separate from handling their estate. And you know, that's also good to bring forth in this conversation, that one's agent can be for one thing or another.
Yeah, absolutely. And sometimes people think, you know, oh, my son is a nurse, and so I really want him to be my healthcare agent. And my daughter is a banker, so she would be a really great agent for managing my finances. You know, I think it's important to think about the traits and experience of the people that you're considering appointing. But I know that's an ideal situation where somebody has somebody in the family that's great at managing money and somebody with healthcare experience. But you know, if you think along those lines, and you can appoint the same person for both, absolutely. We see that a lot.
So we have 15 minutes left. And what I see is that the questions that people that are here and listening have sometimes can really help us get more deeply into understanding the issues. I mean, your presentation was wonderful and complete. And, you know, but it was a lot of language maybe we're not familiar with. So I would like to encourage people to ask their questions now in this time we have. Does that sound right?
Sure, that would be great. And
Yeah,
I guess another nuance of when you ask about the power of attorney for finance versus power of attorney for healthcare or healthcare directive, you can fill out a healthcare directive even if you don't have an agent you want to appoint. If you were filling out a durable power of attorney for healthcare, that would be appointing an agent and saying what powers they have. So that's one little nuance there. And I really, you know, we get, like I said, we get a lot of, when I do these presentations, I have a lot of older adults saying, I really don't have anybody I would trust to make healthcare decisions. But I think the directive is just, it might even be more important in that case because you can have it on file with your doctor and it can spell out your wishes for end of life care, whether you have somebody to make those decisions or not. So it's still a really important document, whether or not you have somebody to appoint.
That's a great point. Thank you for that. Yeah, I would love to hear from, you know, other folks. And Robin, thank you so much. Because each situation really helps us understand the whole of it more deeply, right? So I would really ask and encourage anybody out there now to share a question. And, you know, obviously you can't give a legal answer for them, but you can discuss the subject, which is really helpful.
Sure.
Okay, my main concern is my health. You know, when things start happening with me and I do have someone that I'm concerned about, you know, carrying out all of my wishes, my question is, once I appoint that person, say, if I have family members, can they contest to that person that I appoint to take care of every need that I want? I don't want it to switch up. When something happened to me, this person will be responsible for everything that goes on. Will my family members be able to get in the middle and try to change things around?
Well, under the law, if you appoint a healthcare agent, then that person takes priority over anyone else.
Okay.
But practically speaking, I know if someone's in the hospital and people are arguing about their care, you know, doctors might be really confused about what to do, especially, you know, if it were a situation where your instructions to the agent were to not continue life-sustaining treatment if you had a terminal illness. And other family members were saying, yes, they wanted that. The hospital might require the agent to go to seek an order from the court in order to withdraw the treatment because the hospital's worried about their own liability.
Okay,
so
so
the agent is supposed to take precedence, but practically speaking, hospitals might get nervous if people are fighting.
Okay, so that agent that she might appoint might be in a situation where the hospital doesn't listen to them and they need to get bigger guns, if you will. to really stand up for her wishes. So that's sort of the picture, if you will.
Yeah, and I've seen that happen in the probate court where the agent might seek instructions from the court. They can seek instructions about a specific decision. And I think especially if it's a really big decision, like withdrawing artificial nutrition or something like that at the end of somebody's life, you know, the hospital, if other people are arguing about it, the hospital might be wary and, you know, not wanting to have the agent make such a big decision without a court weighing in. But you know, if you have people that you know might cause trouble and you don't want them making decisions for you, you can name them also as people that you don't want to make decisions.
Okay.
And I
you
know that sounds
mentioned
harsh, but
that.
it might help your agent.
You mentioned that. That's
Working
a
with
kind of
hospitals.
a big deal. Kristen, you mentioned that you can actually specify, I don't want X or Y involved in this decision making, and that surely would be some help.
Okay.
Yeah, if you have it in writing, you know, they are supposed to honor your wishes that are in writing. And especially, I think it's just especially important too to have copies of the document on file with any doctor that you visit regularly or medical system, you know, whether it's Kaiser or John Muir or another one. They probably have procedures to keep a copy of that on file so it can be easily accessed when the time comes.
Right. Because my concern is, I know what my wishes are. And so I don't want to be in a situation when I'm getting ready to leave up out of here. I don't want none of that stuff. I just want to go home. I don't need nothing. And I'm right now, and nothing's going on with me, but I'm having people feeling totally different, telling me what they're going to do. If I want to be cremated, I want to be cremated. I don't want to be on a respirator. I don't want none of that. I don't want no treatments. And so I need something, like I say, as soon as possible, because I don't want to get caught in a situation. And if I want to leave out of here the way I want to leave out, I don't want no one to decide I need to go in the ground. And that's what the drama is. I'm having people telling me that it's traditional that my family go in the ground. I don't want to be in the ground. I want my wishes carried out. And I don't know, whatever I need to do to make sure those documents get to where they're supposed to go. And I just need my decision. It's my decision. And it's like right now, I don't have a choice. I have family members telling me that's not how it's going to go.
Yeah, and those are your wishes. They need to be respected.
Yes.
So you then maybe, Michelle, need to write a durable power of attorney and say, this person is not somebody I want weighing in about my decisions. And this person is not somebody, and this person is. And then make sure, if you are in the healthcare system, you know, where people need to know what your decisions are, that those papers are not buried somewhere nobody can find.
Right. And that's my concern. That's my concern. If something were to go down, these papers, I mean, I would have a copy, correct? Or the person that's caring for me would have a copy. I mean, would there be any other copies somewhere that they can, you know, they can get the copies? And because I know how my family operate, and they the type of people, it's got to be their way. So I need to make sure if something were to go down, these papers need to be somewhere that they can be pulled up immediately, for it won't be no problem.
So what we advise is that you keep a copy. You have the original. You provide a copy to the agent or agents that you've appointed. You provide a copy to any regular doctor or medical system like John Muir or Kaiser, so that if they have a process for keeping that on file. And then some people recommend, and I think a lot of times this is, you know, for older adults who might be in poorer health, to have a copy on the fridge in an envelope, because apparently emergency response personnel know to go and look at the fridge. Or, you know, if somebody has a hospital bed at home, you might post it at the head of the bed on the wall, you know, anywhere that it's clear that this is a really important document. But I do, I think it's a really good idea for your agent and your doctor at the minimum to have copies.
Gotcha.
And, you know, like I said, we do recommend, if people are able to, that they speak with an attorney to talk about a full estate plan, including the healthcare directive and durable power of attorney for finance. But we did provide the link for the California Medical Association healthcare directive. You know, sometimes people choose to do that on their own while they're waiting to get an appointment with a lawyer or something like that, just to have it. You know, it sounds like that's something on your mind. So
yes, it is.
I do want to say that dealing with lawyers generally is expensive. Yeah. So, and, really, what, 5 minutes and you're like out, you know what I mean? So, so Hera, we're going to find out more about them. We're going to put that information out there.
Mhm.
You've really shared with us some really practical things, and that's what this webinar and our work is really all about, is, how can we help people, like, without, without
Yes.
having to just feel overwhelmed, and it's impossible.
Yeah, it is overwhelming. And one thing I would have people consider is, because I do work in conservatorships, I see how expensive and time consuming and embarrassing they can be to have all your personal information out there. If you're able to afford an estate planning attorney, it's a lot cheaper in the long run than having a conservatorship later on, which, like I said, can be, in the tens of thousands of dollars, if not more. Estate planning attorneys cost a lot less than that, and HERA is on a sliding scale according to your income, and so that can be a really great option. And the Bar Association also has the lawyer referral service, where we had that in our materials too, where you can ask about if there are any pro bono or low cost attorneys. And I'll send you the information for those three: ACBA and HERA and Contra Costa Senior Legal
Yeah.
Service.
In our write-up, I'm going to really make a point to put that information up front and center.
Great. Yeah, it's just so important that, it's something that people want to put off, and it's scary to think about end of life decisions. But if you can make those decisions now, it just makes it so much easier for the decision makers in the future, and it makes it so that your wishes will be carried out.
So the option is DPOA, or wait till it's too late and conservatorship.
I mean, yeah, that's a pretty stark option, but yeah, and sometimes, unfortunately, even when people have DPOA, if that's abused or the agent is unavailable or otherwise unable to act, then somebody might still need a conservatorship later on. But the best chance to avoid a conservatorship is getting these documents in place, so you have somebody who can step in.
And just to mush up this point more in this conversation, to say who you don't want is nothing I've ever heard before. And it sounds like it's, pretty practical to say who you don't want.
Yeah, I think so.
Yeah,
especially in the healthcare context, because somebody might be a great friend, but maybe your religious beliefs differ from theirs, and so they just wouldn't be able to bring themselves to make a decision that you would want. So you just really want to, even though it's so hard, you want to talk to the person, because I think that is a gift that you can give them, so they can know that they're honoring your wishes instead of trying to determine what they might be.
So we do have a few minutes left, and I've really stepped in here because I really thought this was meaty and important in a very immediate way. And I thank you, Michelle, for sharing with us and asking and so on, and Robin too, and Serene and Karen and Nitra. We don't have too much time left, but do you have anything you want to bring forward? Yeah.
Michelle, I wanted to tell you what we recommend for our caregivers and loved ones and so forth. To consult with your doctor, get a DNR and put it on your refrigerator.
Okay.
What happens when EMTs come in, let's say you have a bad fall and they come in, they will assume that you want all the bells and whistles of the tube feeding and every heroic effort, when you really don't. And if you don't have a DNR that you can physically hand to them, they will assume that you want the whole ticket. Okay. So if you are doing that with the DNR, you could also put your wishes on a sheet, and who you do not want to be right there with the DNR.
Gotcha. Okay.
That way it's on your refrigerator, on a magnet, off to the side somewhere. But that's the first place EMTs tell us that they look when they're trying to determine whether or not to take heroic measures with someone who has a bad fall or heart attack, so forth. So that's your guarantee right there.
Gotcha. Okay. Thank you.
Your doctor signing off on it with you makes it a legal document.
Gotcha. Thank you.
Okay. I didn't know I was on mute. I kept trying, hey.
Oh no, like why are they ignoring me?
What is your name? I'm looking at two Kellenhers.
I'm one and the same. I'm Karen Kelleher.
You are, okay. And then there's another person here, but we don't know her name.
No, we don't.
Okay, that's okay. Okay.
Incognito, I guess.
Are you incognito there under Karen's other name?
Anitra's here, I
My
think.
name is showing up as Karen. That's
Yeah.
Serene. I don't know why.
Oh, look at you, Serene. You've got my name too.
Yeah, I don't know why.
Hi, Karen.
Hi, Karen.
Sisters by a different mister.
Clueless today. Didn't appear that way earlier.
Oh, that's funny. That is funny.
Thank you all so much for having me present. Unfortunately, I have a 4:00 meeting that I need to jump to.
Okay.
But I'll go ahead and send you the information on HERA and Contra Costa Senior Legal Services and the Alameda County Bar Association Lawyer Referral Service. And then just let me know if you have other questions.
And I'll send you the write-up, Kristen, and if you could get it back to us before the end of the day on Monday, and then we'll put it in our newsletter that comes out on Wednesday.
Sure, that sounds great. Thanks a lot.
Thank you, Kristen.
Thank you.
Bye.
Bye-bye,
Hope you all have a great
Kristen.
day.
Bye. Thank you, everyone.